Good afternoon, everybody. Welcome. Thank you for joining us today. My name is Tom Miles, and I'm the Dean of the Law School. It's a great pleasure to welcome you today to our first Mondays event. I think as many of you know, our first Mondays event is one of our great traditions with our alumni at the law school. Each fall, we gather as the new Supreme Court term approaches, and we invite members of the faculty to share their insights into some of the issues currently proceeding before the court, and also to reflect on recent decisions in the prior terms. And to our alumni, I extend a big thank you for attending, and I also thank you for your ongoing engagement with law school. I also want to give a special welcome to members of the media who are with us. Thank you so much for joining us. The University of Chicago has as its goal intellectual inquiry to expand human knowledge, and then to share that knowledge with the world. And in pursuit of these ambitions, our faculty aspire to produce field-defining ideas and push the boundaries of knowledge. And at the same time, we believe in transformative education, education that's participatory, that draws students into the intellectual conversation. So it's a great privilege today to share with you some of that faculty expertise and that commitment to great teaching and sharing of knowledge. So I will proceed to introduce our panelists, who are Will Baude, Sarah Konsky, and Jeff Stone. I will try to be brief and in describing to you their many accomplishments so that we can jump right into the conversation. Will Baude is the Harry Kalven Professor of Law and Faculty Director of the Constitutional Law Institute at the law school. He received his undergraduate degree in mathematics here at the University of Chicago, and then his law degree from Yale. He clerked for then Judge Michael McConnell of the 10th Circuit, who I hasten to add is also our graduate and former faculty member here. Will then also clerked for Chief Justice John Roberts on the Supreme Court. And before joining our faculty, Will was a fellow at the Constitutional Law Center at Stanford and a lawyer at the Robbins Russell firm in Washington, D.C. Will is a scholar of constitutional law, constitutional interpretation, and federal courts. He is author of numerous articles and co-author of a leading casebook on constitutional law. He's also an editor of the Supreme Court Review. Sarah Konsky is Clinical Professor of Law and Director of the Jenner and Block Supreme Court and Appellate Clinic here at the law school. The clinic represents parties and amici in cases before the United States Supreme Court and other appellate courts. Professor Konsky received her undergraduate degree at the University of Illinois at Champaign-Urbana, and she is a graduate of our law school as well. She served as a law clerk for then Chief Judge Mary Schroeder of the U.S. Court of Appeals for the Ninth Circuit. I hasten to add, Chief Judge Schroeder is also a graduate of our law school. And before joining our law school faculty, Professor Konsky was a partner at Sidley and Austin. Professor Konsky is also an elected member of the American Law Institute. And I'm delighted to introduce Geoffrey Stone, who is the Edward H. Levi Distinguished Service Professor of Law. He is a graduate of our law school and joined our faculty in 1973, marking his 50th year teaching on our faculty. Congratulations, Jeff. And before joining our faculty, he served as a law clerk to Supreme Court Justice William J. Brennan, Jr. He has also served as dean of our law school and provost of our university. Professor Stone's a noted First Amendment scholar and the author of many books on constitutional law. He's also co-author of a leading casebook on constitutional law, although I will note it's a different leading casebook than Professor Baude's. And his most recent book, co-authored with Lee Bollinger, is entitled A Legacy of Discrimination, published by Oxford University Press. Professor Stone writes op-eds for various newspapers with great frequency. He also is an editor of the law school's Supreme Court Review and is a member of numerous academic societies. So welcome to our panel. I'll begin by asking each panelist to share some opening remarks, to preview cases for the upcoming term, look back on cases in recent terms, and then we'll proceed to open the floor to questions from our audience. Thank you again for being here. Please submit your questions via the Q&A box. So now I will turn the program over to Professor Jeff Stone.
Okay, I am delighted to be here this afternoon. And I will focus first on the Supreme Court's two affirmative action decisions in the spring of 2023, one of which held that the University of North Carolina's affirmative action program violated the Equal Protection Clause of the 14th Amendment, and the other of which held that Harvard's affirmative action program violated Title VI of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, religion, or national origin by any private organization engaged in interstate commerce. These were both unprecedented decisions. Indeed, in every Supreme Court decision since 1978, the court has rejected the argument that affirmative action necessarily violates either of these provisions. I'll begin with the Equal Protection Clause. I should note that although the court has consistently rejected the argument from 1978 to 2023 that affirmative action necessarily violates the 14th Amendment, it has held that certain forms of affirmative action in higher education were unconstitutional. For example, strict quotas guaranteeing the admission of a set number of Black and other minority students, and policies that automatically added a specific number of points to the applications of students because of their race, and programs that made admissions decisions based on points. Fundamentally, though, from 1978 in the Baude case until the 2023 decisions this spring, the Supreme Court has consistently upheld affirmative action programs that simply take race into account as one relevant factor among many in making admissions decisions. For example, if a college considers high school grades, SAT scores, letters of recommendations from teachers, musical talent, interest in economics, and considerations in making its own admissions decisions, the court has consistently held that it can also take race into account as affirmative action in assessing a student's admission. Indeed, although in last spring's decision, all 6 Republican-appointed justices held that any consideration of race was now unconstitutional, in the 45 years before this term, 8 of the 11 Republican-appointed justices not now on the court voted to uphold the constitutionality of affirmative action programs of the sort I just described. This shows how far to the right the court has now moved. Now, why, though, do I think that the court's invalidation of affirmative action was wrong? First, obviously, there is the issue of precedent, indeed 45 years of precedent. But as we know from the court's 2022 abortion decision in the Dobbs case, these justices don't give much respect for precedent when the precedent is inconsistent with their strongly felt personal or ideological views. But putting aside my own disappointment in the outcome of the case, let's also take a look at the substantive correctness of the court's affirmative action decisions. First, there is the statutory issue in the Harvard case. Was the 1964 Civil Rights Act intended to prohibit affirmative action in admissions or in employment decisions by private entities? The Civil Rights Act of 1964 was first proposed in an executive order by President Kennedy in 1961. In proposing the legislation, Kennedy introduced the concept of affirmative action by stating that government contractors must, quote, take affirmative action to ensure that applicants are employed in a manner that achieves racial fairness. Then, 3 years later, President Johnson, who ultimately brought about the enactment of the Civil Rights Act of 1964, explained that, quote, you do not wipe away the scars of centuries by saying, now you are free to go where you want and do as you desire and choose the leaders you please. You do not take a person who for years has been hobbled by chains and liberate him, bring him up to the starting line of a race, and then say, you are free to compete with all the others and still justly believe that you have been completely fair. Equal opportunity, he said, is essential, but not enough, not enough. In light of those observations, it is difficult to believe that the Civil Rights Act of 1964 was affirmatively intended to prohibit affirmative action for historically discriminated against racial minorities. And that, no doubt, is why the act was never interpreted that way until this past spring. That is, until now, the Civil Rights Act has never been interpreted to prohibit affirmative action of the sort I described above. Then there is the constitutional issue. It is true that the Equal Protection Clause provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. But of course, that cannot mean literally what it says. A state, for example, can prohibit 12-year-olds from driving, and it can prohibit persons without law degrees from practicing law. What then does the clause mean? Does it mean that historically discriminated against minorities cannot be given special advantages to address the serious effects of past and present discrimination? Certainly, LBJ didn't think so. Indeed, at the time that the Equal Protection Clause was enacted, many states had programs designed to give advantages to Black citizens and former slaves. No one then thought that this was unconstitutional. So what then does originalism tell us about the meaning of the Equal Protection Clause? I want to make one final point on this subject. In his opinion in Baude, Justice Powell maintained that affirmative action was constitutional because it was necessary to promote diversity in education and elsewhere. There's no doubt that such diversity is valuable, but that was not, as President Johnson implied, the core reason for affirmative action. As Justice Brennan wrote in his concurring opinion in Baude, quote, government may take race into account when it acts to remedy disadvantages cast on minorities and past and present racial prejudice. That, in my view, given our nation's horrible history of discrimination against racial minorities, and especially Black Americans, is the truest and most compelling justification for affirmative action. And as we have seen, with ever more Black lawyers, doctors, professors, judges, senators, reporters, members of corporate boards, and so on, affirmative action works. And as someone who has been a professor for half a century, a dean, a provost, and very involved in higher education generally, I want to be sure you understand that these institutions do not admit unqualified minority students. Rather, we have many, many more qualified applicants than we can admit. So one fact colleges and universities have taken into account for decades in choosing among those applicants was race as a means of achieving not only diversity, but justice. The plain and simple fact is that we cannot and should not ignore the horrible effects of centuries of severe racial discrimination by our nation. Affirmative action is simply one way of moving us towards a more just and more equal society. And that is what 3/4 of the prior Republican appointed justices thought. Now it is 0. The second decision from last term that I will discuss is 303 Creative versus Elenis, which involved the constitutionality of Colorado's anti-discrimination law, which prohibits all public accommodations from denying the full and equal enjoyment of its goods and services to any person based on race, creed, gender, religion, national origin, disability, or sexual orientation. Lori Smith, a resident of Colorado, wanted to expand her graphic design business, 303 Creative, to include services for couples seeking websites about their prospective marriages. But because of her belief that marriage can only be between a man and a woman, she would not make websites celebrating the marriage of two people of the same sex. She therefore challenged the constitutionality of the state's anti-discrimination law on the ground that, as understood and applied by the state, it would require her to make such websites for same-sex couples if she made them for opposite-sex couples. Smith maintained that the law, as so understood, would violate her First Amendment right not to speak. The court, in the same 6-3 decision, held that the application of the law in this situation would indeed violate Smith's First Amendment rights. Justice Gorsuch wrote the opinion of the court. He maintained that the state cannot constitutionally compel an individual to convey a message with which she disagrees. In this case, Gorsuch explained, because Smith would produce a final story in her website design for each couple using her own words and her own artwork, Colorado seeks to compel speech Ms. Smith does not wish to provide. Gorsuch therefore concluded that, as this court has long held, the opportunity to think for ourselves and to express those beliefs freely is among our most cherished liberties and part of what keeps our republic strong. Thus, the 6 Republican-appointed justices all voted to hold the Colorado anti-discrimination law unconstitutional as applied to Smith. Justice Sotomayor, joined by Justices Kagan and Jackson, dissented. In a strongly worded dissent, Sotomayor declared that, for the first time in our history, the court grants a business open generally to the public a constitutional right to refuse to serve members of a protected class. The law in question, Sotomayor maintained, targets conduct, not speech, for regulation of the act of discrimination, and has never constituted protected expression under the First Amendment. Central to Sotomayor's argument was her observation that the Colorado law was not expressly directed at speech or at any particular message. It simply prohibited discrimination generally. As she noted, a law that prohibited any person to make statements expressly opposing same-sex marriage would clearly be unconstitutional. But that, she maintained, was not this law, which simply prohibited discrimination, whether by a restaurant owner who refused to serve same-sex couples, or a hotel that refused to permit Asian people to stay there, or a car dealership that refused to sell cars to women. In short, she argued that the law in this case was not directed in any way at speech or at any specific message. In this sense, the law had only an incidental effect on speech. To illustrate her point, she invoked the court's 1968 decision in O'Brien versus United States, in which the court held that a law prohibiting anyone to destroy a draft card was constitutional as applied to a Vietnam War protester who burned his draft card to express his opposition to the war. Justice Sotomayor was sharply critical of the majority's failure to address this facet of First Amendment jurisprudence. Moreover, Sotomayor maintained that preventing the unique evils caused by acts of invidious discrimination in the distribution of publicly available goods, services, and other advantages is a compelling state interest of the highest order. As an illustration, she pointed out that when a young Jewish girl and her parents come across a business with a sign out front that says "No dogs or Jews allowed," the fact that another business might serve her family does not redress that stigmatizing injury. Indeed, she noted the court's holding in its 1984 decision in Roberts versus United States Jaycees, in which the court held that the application of Minnesota's anti-discrimination statute to compel the Jaycees to accept women did not infringe on the organization's First Amendment freedom of expressive association, because the state's anti-discrimination law did not aim at the suppression of speech and did not distinguish between prohibited and permitted activity on the basis of viewpoint. Instead, the court explained that the law's purpose was to eliminate discrimination and to assure the state's citizens equal access to publicly available goods and services. That goal, the court reasoned, was unrelated to the suppression of free expression and plainly serves compelling state interests of the highest order. Time and again, Sotomayor continued, businesses and other commercial entities have claimed constitutional rights to discriminate. And time and again, he said, this court has courageously stood up to those claims until today. In this case, she added, a business claims that it would like to sell wedding websites to the general public, yet deny those same websites to gay and lesbian couples. Smith could have avoided the problem, she observed, simply by making no wedding websites. The court's decision, she concluded, is a grave error. Responding to the court's invocation of Roberts versus Jaycees, Sotomayor pointed out that a parade is neither commercial activity nor is it a pure act of free expression. Thus, she maintained, that case did not control this one. One final point. How do you think the justices in the majority in this case would have voted in Smith if Smith refused to make marriage websites for Catholics? And with that, it's my pleasure to turn the floor over to Sarah Konsky.
Thank you. It's a delight to be here with you all virtually today. Thank you for joining us. I wanted to talk about a few cases today that I think are a continuation on some of the themes that Jeff was just discussing. The first is some consolidated cases from last term called the Brackeen cases. In a 7-2 opinion, the Supreme Court rejected petitioners' many challenges to the constitutionality of a federal law called the Indian Child Welfare Act. The case is significant for a number of reasons, but one of them personally is that it was a case in which our clinic was co-counsel at the merit stage for some of the tribal respondents. So we were honored to have the opportunity to work with the team of lawyers in representing tribal respondents in the Supreme Court in this case. So by way of background on this one, ICWA is a federal statute that was passed in 1978 to protect Indian children. Justice Gorsuch in his Brackeen cases had a excellent and powerful summary of the history that led to the passage of ICWA, but to borrow a bit from Justice Gorsuch, this act came as a direct response to the mass removal of Indian children from their families by state officials and private parties. That practice, in turn, was only the latest iteration of a much older policy of removing Indian children from their families, and that this dissolution of Indian families had had devastating effects on children and parents, and also presented an existential threat to the continued vitality of tribes. So in 1978, more than 40 years ago now, Congress responded by passing the ICWA statute. That statute contains various provisions aimed at addressing the crisis in Indian families in court proceedings. And at the bottom, it installed substantive and procedural guardrails against the unjustified termination of parental rights and removal of Indian children from tribal life. The statute has been in effect since 1978 and has been lauded as a gold standard for custody and family law standards. In these Supreme Court cases, the petitioners challenged ICWA as unconstitutional on many different grounds. Again, this was 4 consolidated cases, and among them, they raised a lot of constitutional challenges. petitioners asserted that ICWA was exceeded Congress's authority and that Congress lacked the authority to enact ICWA, that several of ICWA's requirements violated the anti-commandeering principles of the 10th Amendment, that it employed racial classifications that unlawfully hindered non-Indian families from fostering or adopting Indian children, and that there were non-delegation doctrine issues with the statute as well. In a 7-2 decision authored by Justice Barrett, the Supreme Court rejected all of the petitioners' challenges to ICWA. Justice Barrett led the majority opinion by explaining that the issues were complicated, but the bottom line was that the court was rejecting all of the petitioners' challenges to the statute, some on the merits and some for lack of standing. A number of takeaways from these consolidated cases. These were another instance where the court was considering a challenge to something kind of old, a 40-year-old statute, and accepted cert kind of two sweeping challenges by granting the 4 cases, together with numerous constitutional challenges. So again, a big challenge to a big statute. From respondent side of the case, of course, the decision upholding ICWA was a very important victory for Indian children and tribes and families. The case also, to me, reflects that while the court is taking more cases that are of this nature, not all of the challenges are successful in this court. And Justice Gorsuch, again, wrote a powerful concurrence in this case, again, championing tribal rights and protections. So this is a case that, from last term is significant for many reasons in our view. Moving on to this term, another case in this bucket is Loper Bright Enterprises versus Raimondo. Another case revisiting things from about 40 years ago, and this is the case involving the Chevron Deference Doctrine. If you attended this First Monday's event last year, you may remember Professor Macy was talking about what was going to happen with the Chevron Doctrine and what its future might be. It looks like the court is going to answer that question, either in whole or in part, this term. The facts of the Loper case are relatively unremarkable. It involves a federal statute in which Congress authorized the National Marine Fisheries Service to require commercial fishing vessels to carry federal observers or monitors who would be placed on these vessels to ensure that the vessels were complying with fishing regulations. The statute, importantly, doesn't say who pays for these monitors in relevant cases. So the agency here issued a regulation saying that at least in some cases, domestic fishing vessels in the Atlantic herring fishery would be required to pay the salaries themselves of the observers that needed to be on these vessels. And this resulted in litigation in which the vessels and the fishery said that Congress hadn't authorized this. So as you may recall, the Chevron Doctrine comes into play in this circumstance. That was a decision almost 40 years ago in Chevron versus National Resource Defense Council that announced a 2-step procedure for examining whether an administrative agency's interpretation of a statute is lawful. So as you may recall, at step 1, the court first looks at whether the statutory language is clear. If it is, the court gives effect to those clear terms. But if the court instead decides the statutory language is silent or ambiguous, then the analysis goes to Chevron step 2. And that's where the court must defer to the agency's reasonable interpretation of the statute. In this case, a majority of the DC Circuit panel ruled for the agency applying this Chevron analysis. It concluded that the statute was silent on whether the agency could require the fisheries to pay in this circumstance, so deferred to the agency. The dissent disagreed and said the statute actually was clear because it unambiguously did not authorize the agency to require the fisheries to pay. So Chevron, as you probably know, has fallen out of favor. It's been criticized widely by academics and judges, It's been criticized by justices on this court. And these criticisms are far-reaching and probably could take up most of our time today to walk through. But everything from separation of powers concerns, saying that Chevron has given to Article 2 agencies powers that belong in Article 3 courts, all the way to workability concerns, saying that Chevron is not working in practice. So the petitioner in this case gave the court two different routes to take in the case, and the court granted cert on a compound question. The first part of that question is whether the court should overrule Chevron. And the second part is the more limited approach of whether the court should clarify that statutory silence in circumstances like petitioner says are present in this case, where there's express powers granted in one part of the statute and silence in another, should not constitute an ambiguity, getting you to step 2, Chevron deference. In turn, the government argues that the court should keep Chevron. It raises its own separation of powers and history arguments. It also raises a reliance argument, explaining that Congress has been legislating against this backdrop of Chevron, meaning that it's legislating with the assumptions that agencies will be the ones interpreting silent or ambiguous statutes. So it seems likely, I think most agree, that Chevron's not going to survive this case, at least in its current form. Perhaps there's still a question of, exactly what the opinion in this case will look like, whether this is the case to just overrule Chevron or whether it instead takes another approach to narrow it based on the facts of this case. I will note that the practical implications of this case are a bit unclear. There are good arguments to be made that Chevron isn't currently doing a lot of work in a lot of cases. Litigants are often not raising Chevron and deference as the primary argument, are trying to convince the court that the statutory language is clear or that there are other grounds on which to decide the case. You're more often seeing Chevron kind of buried at the end of briefs these days. Petitioners in this case point out that the court itself hasn't been citing to Chevron in agency cases, and that other doctrines like the major questions doctrine instead have been supplanting it. So there may be a question, regardless of where the court goes with this case, of how big a change it will constitute in practice. The last case I wanted to touch on today was a case that is different than the previous ones we've been discussing. That is more of your kind of typical circuit split case, stemming from arguably technological changes that have arisen. This case is called Loper versus Atchison Hotels and involves the issue of tester standing under Article 3. It's an ADA case. And as you probably know, the Americans with Disabilities Act requires places of public accommodation to take certain steps to be accessible to individuals with disabilities. And an issue in this case is an implementing regulation that requires hotel owners and operators to identify and describe accessible features in hotels and guest rooms offered through reservation services in enough detail to reasonably permit individuals with disabilities to assess whether there are sufficiently accessible guest rooms for them. The idea behind this is that if an individual with a disability is traveling to a hotel, he or she needs to know before they get there whether they'll be able to use the hotel room given their accessibility needs. This case is at the intersection of tester standing and the internet. The respondent in this case, Deborah Loper, is an individual with disabilities. She requires a wheelchair and is visually impaired. And she has been operating as a ADA tester, meaning that she goes to hotel websites to determine whether they are compliant with this regulation and then initiates lawsuits where they're not. The standing question in this case arises because while she's doing this work on the websites, she is not intending to visit the hotels herself, so is acting as a tester. There are implications in this case potentially for businesses, places of public accommodation, and individuals with disabilities. In short, the petitioner argues that this is the sort of informational injury at most in the case that the court has held does not give an individual Article 3 standing. So here, because the individual doesn't intend to go to the hotel, she's merely suffered an individualized informational injury. The respondent in turn argues that by visiting these websites and being deprived of the information guaranteed by the regulation, that in fact is discriminatory treatment that is cognizable under Article 3. There's some arguments in this case that are specific to the statutory language, but some broader questions about the standing of testers that may have other implications for areas like housing discrimination and physical disability suits under the ADA. I will note quickly that the government came in as an amicus for neither party in this case, and it notes at the outset that private suits by testers are an essential complement to the government's enforcement of Title III, and urges the court to retain prior precedent, saying that tester status alone does not negate standing, but then says here that the plaintiff doesn't have standing given the specific language of this provision and the rights conferred under it. So if you are interested in following the court's standing precedents, or have reason to be following these sorts of accessibility and tester standing cases, this is a case to keep an eye on. And I'll add note quickly before I pass it to Will, there are also some really intriguing mootness issues in this case. So if you're a fan of the court's mootness doctrines, it's one to check out on those grounds as well. So with that, I will conclude my remarks and pass it on to Professor Will Baude.
Thanks, Sarah. And to continue on the theme of standing, I want to talk about two things. One, a sort of a trend we saw in the court's, another aspect of the court's standing jurisprudence last term, and then a substantive constitutional issue, a huge issue on the docket for this coming term. So from last term, one of the other big transformations I think we're seeing or starting to see is in the court's attitude towards the standing of the states. When I was in law school, which was not that long ago still, it was not that common to see cases at the Supreme Court that were, a state versus the federal government. That would be an unusual constellation. But in 2007, the Supreme Court decided a case called Massachusetts versus EPA, where it allowed a suit by the state of Massachusetts against the EPA and the second Bush administration about the regulation of climate change. And in the course of deciding that case, and the course of deciding that Massachusetts was the right party to sue, the court said some specific things about sort of the idea that states should be given what it called special solicitude in the analysis of standing, and the question of whether or not this lawsuit should be brought. That is, there might be a case where ordinary people would still say, this suit is too speculative, the injuries are not quite ripe, we're not sure the courts would get involved. But because it's a state, states had kind of, the idea is that states have given up a huge portion of their sovereignty in forming the union, and so in exchange the union owes them some special solicitude in hearing their claims when they come into court. Massachusetts doesn't have the ability to resort to the kinds of diplomatic and other measures that countries do in deciding to negotiate and deal with issues like climate change, so maybe the Supreme Court should give it some special solicitude in coming forward. Now, what exactly this meant as like a doctrinal matter is complicated. Law professors debated. I won't bore you with that here. But the trend since then has been remarkable. So over the course of the Obama administration that followed shortly thereafter, there were 58 different lawsuits initiated against the administration by Republican state attorneys general. During the Trump administration, I think there were 155 lawsuits initiated against the Trump administration by various Democratic state attorneys general. We've already seen, I think, 59 against the Biden administration. I may be missing one that was filed recently. Just the number of these lawsuits have become staggering. It's become a standard part of sort of a somewhat partisan operating procedure, that when there's a new administration in power, the states that are controlled by the other party will sue for almost any major initiative and try to litigate it. Combined with some other trends, including some new and perhaps more polarized district court appointments, the increasingly widespread grant of so-called nationwide or universal injunctions, where one district court might enjoin a policy nationwide, the Supreme Court's increasing willingness to deal with these cases in an expedited fashion, or even without hearing full argument and briefing on the court's emergency docket. All those things together mean that compared to 20 years ago, just the number and speed with which major political issues are brought before the Supreme Court has changed. And in my view, not necessarily for the better, just putting the court at the center of a lot of these things. Again, the court may be in part or almost entirely to blame for that, but I think they've found themselves in this position, and not all of them are entirely happy with it. And I think we started to see that in a few cases from last term, where the court started to send either subtle or sometimes more explicit signals that it's going to be more skeptical of these kinds of lawsuits in the future. So this came up as a kind of one of the many issues in the Burkeen case that Sarah's already talked about, where the court was skeptical of the state of Texas's ability to have standing to challenge ICWA. But it came up much more explicitly in another case involving Texas, United States versus Texas, where the state of Texas tried to challenge a number of immigration enforcement priorities in the Biden administration, to complain essentially that the administration was not arresting and detaining immigrants that Texas thought that it should. And the Supreme Court, in an opinion by Brett Kavanaugh, said, this is not a lawsuit that the Supreme Court is going to hear. Even though the state of Texas said, look, we have a state interest in who is present and who is in our state. And you've said that states are supposed to have special solicitude, especially in dealing with these kinds of areas where we can't just unilaterally, deal with things on our own. The court said no. The court said this is not the kind of injury that the courts are going to hear. And it even added several points sort of skeptically addressing these kinds of precedents of special solicitude. It said it's true, we have this case, Massachusetts versus CBA, but we don't think it should be read so broadly. We don't think it stands for this kind of broad special solicitude. It dealt with it just in a couple of footnotes, and indeed the dissent in the case complained that the court had basically effectively overruled this idea of special solicitude and was now just giving Texas the kind of ordinary treatment, which meant not letting them come in and sue and complain that the government was not doing more to arrest other people. In another major case brought by states, a challenge to the student loan forgiveness program that was decided under Biden versus Nebraska, the Supreme Court did hear the merits of the case and did decide that the administration's policies had exceeded the best interpretation of the statute. But even in the course of doing that, the court was quite careful to decide on much narrower standing grounds, that it agreed to hear the case only because Missouri has a loan administration program that was sort of directly financially affected by the loan forgiveness plan, and so could show a much more traditional type of standing. And you can look through all the opinions, in a whole range of these cases, and see the court trying to signal that it's going to be a little more wary of these kinds of general claims that just because we're a state and we don't like the policy, we should be able to sue. Indeed, even in another one of the loan forgiveness programs, the court rejected another sort of claim to have standing there, and had several other standing cases. So I think the standing cases as a whole, standing out from even just any one particular case, suggests that the court is at least a little bit aware. Maybe not aware enough. Maybe this won't always come up in the cases where it should, but at least a little bit aware that it needs to do something to get a handle on the constant flood of sort of ideological litigation before the court. Now, that brings us to a case for this on the docket for next term, where the court will not be able to avoid this issue, which is a Second Amendment case about the right to keep and bear arms called United States versus Rahimi. And an issue in this case is the constitutionality of a federal law which prohibits the possession of firearms by anybody who's subject to a domestic violence restraining order. So these are not necessarily people who are felons or even convicted of any offense, but they're currently subject to a restraining order. And under federal law, that means that they cannot possess a gun at all, sort of categorically. The Fifth Circuit held this was unconstitutional, that this violated a very recent Supreme Court case called Bruin, which I know we talked about on a previous First Mondays, where the Supreme Court said that lower courts have not been giving the Second Amendment enough credit. They've not been looking enough to history and tradition. They've been upholding too many laws under the Second Amendment, but it did not give a lot of guidance about what it meant or how you would look to history and tradition or what you would do when history and tradition suggested, that they just didn't have the same problems we have and so on. So this is going to be the Supreme Court's first test about whether it really means that, whether it really wants to inaugurate a sort of new and more aggressive Second Amendment doctrine, and if so, how it's going to work. For my money, I think the Fifth Circuit, along with several other lower courts, have been overreading the Supreme Court's messages and probably striking down a lot more laws than the Supreme Court intended for them to, or than it should. So the Supreme Court tried very hard to say, in deciding whether to uphold a regulation, you should ask whether this is sort of within a traditional government category of regulation. But of course, you don't have to find exactly the same regulation, because even the Supreme Court, even the originals of the Supreme Court, understand that things do change and that you sometimes have to have new laws to address new circumstances. So instead, they call for a sort of a search for analogies, and then the question is, what does that mean? What is the analogy search going to look for? The Fifth Circuit had said, well, there are previous laws disarming slaves, disarming, various other kinds of discrete and insular minorities, but this is not a good analogy. There were laws about requiring people who are potentially violent to post bonds, but these are not quite the same. And the Fifth Circuit was sort of very grudging in its search for any kind of analogy, and then just fell back on its general view that most gun regulations were unconstitutional. I expect that what we're going to see from the Supreme Court is something a little different. So when Amy Coney Barrett was a Seventh Circuit judge, she had a sort of a different view of how to see the history and tradition. And she thought you could distill out of a lot of the history about the Second Amendment a general principle that the government can disarm people who have been proven to be or at serious risk of being dangerous, but you couldn't disarm people who had not been proven to be dangerous, which might mean that some people who have convicted of felonies might still have a right to keep and bear arms if their felonies were not really a matter of what you think it was public danger, but many others would not, and so on. And my guess is we'll see that kind of principle at that kind of level of abstraction resurface in this kind of case. And we'll see the Supreme Court ask, given the way domestic violence restraining orders are obtained, is that enough to be reassured that somebody is potentially dangerous? Should we see a state finding of a domestic violence context as a proxy for dangerousness, or is that a little bit overbroad? If you get into the weeds, the federal statute even has sort of two subparts, one that specifically addresses people who've been proven to be dangerous and another that doesn't. You can even imagine the Supreme Court kind of parsing the statute at that level. So my guess is what we'll see from the Supreme Court is both a signal that courts shouldn't be too quick to assume that all gun regulation is unconstitutional. They really do mean that there are sort of important principles of public regulation here, but that those principles will not uphold everything that we've come to be used to now, and we probably will still see several more rounds of litigation with the Supreme Court as they try to work out sort of principles to operationalize this basically new constitutional right. And with that, I'm happy to return things back to our dean, Tom Miles.
Great. Thank you so much. Thank you, Jeff, Sarah, and Will, for that terrific overview of some important cases coming up. So now we'll turn to Q&A, and I encourage all the participants to submit your questions through the Q&A function. A number have come in, and a number have also been, submitted at the time that our participants registered. So we've got a good number of questions. So I will apologize in advance. We can't get to them all, but I will try to group some of them together and pose them to our panel. So it's been kind of a great focus on specific cases that are coming up this term. We got a number of questions in advance about the question of Supreme Court justices and ethics, and questions about whether or not there is likely to be a mandatory ethics code. Is that likely to come from the court? Would it come from some other source? How could those potentially be enforced? So I'll open that up to the panel to sort of say, is there a need for this? Is there likely a response either from the court or from elsewhere in the government?
I'll start by saying a number of justices in public remarks have suggested that there are discussions happening about, an ethics policy or ethics guidelines or something coming from within the court. So it in light of the discussions that are happening around this issue, I wouldn't be surprised to see that first.
I don't think there's any principled reason why the justices on the Supreme Court should not be held to the same types of regulations as other federal judges. And if they had taken their responsibility seriously, they would probably have adopted policies similar to those that apply to the other federal judges. So I do think that's hard to understand why they insisted on that degree of indifference to these issues. And I do think that there are a number of issues that came up this term, last term, that raise questions about why that there should be such regulations. And the justices don't seem very interested in policing themselves in any serious way. So I don't think there's any good reason for not having them.
And I'll add, I think the Supreme Court is in a little bit of a bind because they have for a very long time had a very strong tradition that a lot of these matters are decided by the justices at the individual level. That it would be too dangerous to let the Supreme Court as a whole, and certainly too dangerous to let anybody outside the Supreme Court sort of make collective decisions about the recusals of individual justices. But they are now realizing that, of course, leaving that to the individual level can impose taxes on the institution as a whole. And I guess this is a problem familiar to faculties with tenured faculty members as well, so that it sort of relies on everybody being on more or less on the same page about the norms and appearances of propriety. And when that doesn't happen, they're not sure they can rely on that principle as well. I think it's probably also no secret that a couple of the justices, like Justice Alito, Justice Thomas, fundamentally don't trust the media that reports in the Supreme Court. So I think from their point of view, the reporting that seems like a huge appearance of impropriety to a lot of people who read those media, from their point of view, is just further evidence of the bad faith of those institutions attacking the Supreme Court, which probably makes them inclined to double down, even as many other justices might wish that they could find a way to sort of restore the court's legitimacy in the eyes of the broader public.
Thank you. Thank you all very much. Will, I received a number of questions that I think are directed to you, but of course I invite Jeff and Sarah to comment as well. And they're around your recent work on the 14th Amendment, Article 3, and the argument that you advanced about the disqualification of President Trump. And so a number of questions kind of about that. I think some just an invitation to give a bit more background on your claim, but then also questions about as your argument has been picked up in the wider world, where do you see it going? And is there any world in which, or any way in which that issue would itself reach the Supreme Court?
Sure. Yeah, so I think this is asking about Section 3 of the 14th Amendment, which says that anybody who has previously taken a constitutional oath and then subsequently engaged in insurrection or rebellion can't hold office in the future. Which was an incredibly important provision at the time the 14th Amendment was enacted, dealing with the practical problem of the former Confederates potentially coming back into power in the South. And that has been almost entirely ignored by history for 150 years until recently, as people looked at the events of the 2020 election, and especially the attack on the Capitol on January 6th, 2021, as a possible example of an insurrection or rebellion, which then might trigger the coverage of the 14th Amendment with respect to various members of Congress, and especially former President Donald Trump. In a recent article that's, 126 pages long, I sort of delved into these claims with the co-author Michael Stokes-Paulson and concluded, somewhat to my surprise, that they had a lot of legs, and that probably is the case that January 6th is an insurrection, and that the president engaged in it, and that it's therefore a binding disqualification on the matter of current election law. There have been several lawsuits about this. Actually, there have been many lawsuits about this, many of which are sort of filed by individuals proceeding pro se or have obvious procedural problems, but several of which, one in Colorado and one in Minnesota, are filed by very serious organizations. I think one of them is represented by the former Solicitor General of Colorado, and they are working through the state system relatively quickly. I think if any state were to try to exclude Trump from the ballot, they would almost certainly have to go through the state courts. There's no state that lets the Secretary of State, unilaterally declare somebody an insurrectionist. And if a state court did conclude that was lawful, whether in Minnesota or Colorado or somewhere else, the Supreme Court could well review that. The Supreme Court could well think that's an issue of sufficient nationwide importance that they should step in and figure out whether Section 3 of the Constitution is enforceable, and if so, what it means. So at the moment, it's still an issue kind of in the lower state courts, but it's easy to see a path that could end up in the Supreme Court possibly quickly.
Great, thank you, Will. We've got a number of questions which I think are pertaining to sort of First Amendment. So let me try to group some of them together. So one question that we've received through the chat is to invite the panelists' thoughts on the Supreme Court's recent decision in U.S. versus Hansen. And that pertained to a provision holding that criminal penalties for encouraging or inducing a non-citizen to come or to enter to reside in the United States was not facially overbroad under the First Amendment. And so first, there's a question about what does the panel see as the potential impact of that on immigration, on sanctuary cities? But then also, what are its implications for other kinds of statutes? For example, statutes that might criminalize assistance or encouragement of abortion where it's legal at the state level. So let me invite the panel. Jeff, in particular, I'll call on you if you'd like to opine on that.
Sorry. On the abortion issue, the notion that it can be made illegal to encourage someone to have an illegal abortion is an interesting criminal law question. And to what extent, under existing criminal law, can an individual be held accountable for encouraging someone to commit a murder, or to rob a bank, or to leave her child in a public park on her own? And I actually don't know the answer to that question, but that's a fairly sensible question which has to be asked and answered. And I don't see why it would be different as opposed to the abortion context in a state in which it's illegal. So I'll leave it at that and let the others take on because we're running out of time.
Yeah, I'll jump in quickly if I might. Our clinic wrote an amicus brief in the Hansen case. And one of the issues in that case was that the encouraging or inducing language in that statute was quite broad. The court ultimately adopted a narrow reading of the statute and upholding it, talking about criminal solicitation, so that encouraging and inducing doesn't mean, little offers to do this or that, but it actually means something akin to criminal solicitation of a crime. That said, as our amicus brief argued, there remains a lot of questions for organizations trying to navigate in these spaces as to what's on which side of the line. So it'll be interesting to see how this unfolds in a number of cases from immigration to, as Jeff was saying, abortion and any other number of contexts.
Thank you. I think we got time for one more, and so let me also stay on this theme of the First Amendment, but then also connect it to some of the prior conversation on the standing doctrine. And there's a question about a case that I think there was just a decision from the Fifth Circuit on Missouri versus Biden, which pertains to communications between Biden administration officials and social media companies. And so one is the question about is the concerns about standing that have been discussed, is that likely to have an impact on this case, as well as just any thoughts that people have on the First Amendment aspects of this case?
It's an ambiguous area of First Amendment jurisprudence about the extent to which the government can attempt to influence people to take positions that they believe in. Now, all politicians do that, right? Presidents do it, governors do it, people running for Congress do it routinely. Here, though, it's a little bit more manipulative because it's basically threatening these websites implicitly, not explicitly to my knowledge, but implicitly, that they should conform what they allow to be presented or what they say themselves to the values of the government. And I would say that's highly problematic. Government shouldn't be taking what looks like a kind of threatening situation. Now, it's not explicitly threatening, right? I don't think anybody has said that when the government tells a website that it would be good to take down X, Y, and Z, that they're explicitly threatening something. But they're also putting implicit pressure on them to do it because the government has lots of abilities to disadvantage the organization. And if the government does disadvantage the website because they don't cooperate, that I think would be pretty clearly unconstitutional. So that's, I think, the key issue. Is the government just trying to persuade somebody to do what they believe to be the right thing, or they essentially threatening them with penalty delivered by the government if they don't cooperate.
And on the standing side of it, it's right that these are another example of a case where some of the standing comes from individual states. I think there are also individual plaintiffs, so it may not be an easy case for the court to just say, our previous state standing cases let us get out of this. But I do think that that sort of dynamic I was talking about earlier is the court is going to be aware this kind of makes the case harder for them, in that the lower courts approved sort of astonishingly broad relief, sort of forbidding broad classes of government officials from communicating with broad classes of social media companies entirely. And if they had been forced to deal with the issue at a slightly more granular level, it might be able to sharpen their thinking a little bit in the ways Jeff was describing. You know, if the court's actually forced to engage with, well, okay, who was kicked off of social media and why, and what did the government say to them to cause that to happen? Is that over the line or not? And then they could issue some kind of principles here, especially since this is such an untested area of law. But if the court's only two choices are to say, you know, is the government allowed to talk to Twitter or not? That's going to seem like a sort of impossibly stark question, I think.
Yeah, thank you all very much for joining us. I wish we could go on. We are at the end of our time, so let me thank Professor Stone and Konsky and Baude for sharing their expertise with us. It's been a really terrific hour. And to our alumni and friends, thank you so much for joining with us today. I look forward to seeing you maybe in person soon, but also maybe in another virtual session. So please look for advertisements for that. So thank you all very much for joining us. I look forward to seeing you very soon. Thanks so much. Have a great afternoon.